Josh, what happens to my assets if I don't have an estate plan?
That's a great question, and it points to all of the things that are most important about having an estate plan. The first thing to know is that who inherits from you is going to be governed by what are called the laws of intestacy, the laws of what happens if someone dies without a will. And in some scenarios, it may match exactly what you would do with your will. If you are a family where you have a spouse and you have children that are both of your children and that's it, that's the limit of the complexity, well, the law says in that scenario that your spouse inherits, or if your spouse has passed before you, then your children inherit. That makes sense. Now, there are still costs to not having a will. First and foremost is there's no appointment of an executor. So the person who wants to represent your estate has to go to court to get that appointment. They also have to be bonded for the value of your estate, even if that's your spouse in most circumstances, if there's a lot of assets to be handled. So right away we face costs and difficulties that are easily avoided with the will. There's much more court oversight, much more need for attorney help at every stage of it when there's no will. A lot of that can be alleviated by first waiving certain things that are otherwise required in your will, the bond, court oversight on certain things, and also by spelling out clear instructions in the plan that cover a multiplicity of scenarios. We want a will, trust, power of attorney, whatever it might be, to be like a playbook, so that no matter what happens in your life, there's instructions in the document about how to address it.